Hello everyone, I'm Muhammad Farhan Memarikin, metric number A20BE0127, is a first year student in a Bachelor of Science in Property Management with Honor at University Technology Malaysia Skudai Johor. This video was made for the study purpose in the field of tort law for the subject contract, agency and tort law with code SBEH1093 to meet the requirement of our assessment. The lecturer in charge for this topic is Dr. Zafira binti Abdul Mu'in. Tort. What is tort? A tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which court imposes liability. In the context of torts, injury describes the invention of any legal rights, whereas harm describes a loss or detriment in facts that an individual suffers. In common law, civil law, and the vast majority of legal systems, tort is an instance of harmful behavior, such as physical attack on one's person or interference with one's possession or with the use and enjoyment of one's land, economic interest in under certain conditions, honors, reputation, and privacy. The term derived from Latin tortum, meaning something twisted, wrong, or crooked. The concept encompasses only those civil wrongs independent of contracts. There are three types of tort, which are tort of negligence, tort of nuisance, and tort of trespass to land. But in this video, we will focus on the second type of tort, which is nuisance. What can you see from the picture? Well, those are some of the examples of nuisance that often happens in our daily life. What is nuisance? In general terms, a nuisance is something that annoys or wearing on the nerve by a persistent unpleasantness. It can evoke anger and interfere with comfort and peace of mind. In a regulatory environment, the term nuisance includes anything that results in an invasion of one's legal rights. A nuisance involves an unreasonable or unlawful use of property that results in material annoyance, inconvenience, discomfort, or injury to another person or the public. The unlawful use may involve doing something, for example, piling garbage on residential property. Common nuisances include junk accumulation, animals, noise, dangerous building, sewage and unsanitary condition, and encroachment on the public right-of-way, the interference with pedestrian passage. There are two types of nuisance, public and private. A public nuisance created in a public place or on public land or affecting the moral, safety, or health of the community is considered an offense against the state. Such activities as obstructing a public road, polluting air and water, and keeping explosive. Meanwhile, a private nuisance is an activity or condition that interferes with the use and enjoyment of neighboring privately owned land, which constituting an actual invasion of the property. Thus, excessive noise, noxious vapor, and disagreeable odors and vibration may constitute a private nuisance to the neighboring landowners, although there have been no physical trespass on their land. Action taken. A public nuisance is actionable only by the state through criminal proceeding, injunction, or physical abatement. The same activity or conduct may also create a private nuisance to neighboring landowners and thus result in a civil suit. The conduct of a business in violation of a zoning ordinance creates a public nuisance, but it also may be actionable as a private nuisance by neighbors who can prove a decrease in the market value of their homes as a result. A private nuisance is based upon interference with the use and enjoyment of land. It is actionable only by persons who have a property interest in such land. If the interference merely makes the use and enjoyment less comfortable without inflicting physical damage to the land, the courts consider the character of the neighborhood to determine whether the activity or condition is an unreasonable interference. An activity that causes physical damage to neighboring land will be held to be an actionable nuisance irrespective of the character of the neighborhood. Such cases usually involve vibrations that cause walls to crack or noxious vapors that destroy vegetation. Now, let's dive more deeper and know some examples of nuisance. Example nuisance of public. The term public nuisance covers a wide variety of minor crimes that threaten the health, moral, safety, comfort, convenience, or welfare of a community. Violators may be punished by a criminal sentence, a fine, or both. A defendant may also be required to remove a nuisance or to pay the cost of removal. For example, a manufacturer who has polluted a stream might be fined and may also be ordered to pay the cost of cleanup. Public nuisance may interfere with public health, such as in the keeping of diseased animals or a malaria pond. Public safety nuisance include shooting fireworks in the streets, storing explosives, or harboring a vicious dog. Houses of prostitution, illegal liquor establishment, and unlicensed prize fight are examples of nuisance that interfere with public morals. Obstructing a highway or creating a condition to make travel unsafe or highly disagreeable are examples of nuisance threatening the public convenience. A public nuisance interferes with the public as a class, not merely one person or a group of citizens. No civil remedy exists for a private citizen harmed by a public nuisance, even if his or her harm was greater than the harm suffered by others. A criminal prosecution is the exclusive remedy. However, if the individual suffer harm that is different from the suffered by the general public, the individual may maintain a tort action for damages. For example, if Dynamatic has thrown a large boulder onto a public highway, those who use the highway cannot maintain a nuisance action for the inconvenience. However, a motorist who is injured from colliding with the boulders may bring a tort action for personal injuries. Example case of public nuisance. Case of Attorney General vs. PYA Quarries Ltd. 1957. Quarry work was carried out causing the local community to get dust and tremors from the blast carried out. The court has held that public disturbance arises when a defendant action or activity disturbs the comfort and the reasonableness of a group of people in the particular community. It is unnecessary for the judgment to prove that every member of the community have been adversely affected. It is sufficient to show that there is a class of society from the community group that have received the consequences. Example nuisance of private. A private nuisance is an interference with a person's enjoyment and use of his land. The law recognizes the landowners or those in rightful possession of land have the right to the unimpaired condition of the property and to reasonable comfort and convenience in its occupation. Examples of private nuisance abound. Nuisance that interfere with the physical condition of the land include vibration or blasting that damages a house, destruction of crops, rising of a water table, or the pollution of soil, a stream, or an underground water supply. Examples of nuisance interfering with the comfort, convenience, or health of an occupant are foul odors, noxious gases, smoke, dust, loud noises, excessive light, or high temperatures. Moreover, a nuisance may also disturb an occupant's mental tranquility, such as a neighbor who keeps a vicious dog even though an injury is only threatened and has not actually occurred. Example case of private nuisance. Case of Harsley vs. Esso Petroleum Company, 1961. Halsey lived down the road from an Esso petroleum oil factory. Halsey claimed that the factory emission produced an offensive smell and that the acidic residue from the factory smoke damaged his linen and car paint. Halsey was also kept up at night by the noise from the trucks constantly moving about in the area. An injunction is granted at night to prevent the noise from affecting the neighborhood. The locality and character of the neighborhood is important. Will they determine that the factory could operate without causing nuisance and note that there was little noisy pollution during the day? The smell can be a nuisance. Trespass is sometimes confused with nuisance, but the two are distinct. A trespass action protects against an invasion of one's right to exclusive possession of land. If a landowner drops a tree across her neighbor's boundary line, she has committed a trespass. If her dog barks all night keeping the neighbor awake, she may be labeled for a nuisance. Some nuisances can be both public and private in certain circumstances, where the public nuisance substantially interferes with the use of an individual adjoining land. For example, pollution of a river might constitute both a public and a private nuisance. This is known as a mixed nuisance. Well, I think that's all from me. Thank you for your time.